Hi, here we go again. More hot and developing current events here. We have the case of Jeffrey Epstein. Not everybody's favorite guy in this day and age. But first part, which I'm not going to talk a lot about here, was that it looks like to me it can't be any clearer that he didn't commit suicide any more than JFK did. So we'll see how what develops at that end of the spectrum. The interesting part for me, and I just downloaded an article. It was a very brief article. I may send a FOIA request to the FBI because they went down and searched a private island that Jeffrey Epstein purchased. Private island. What authority did they have to go down there with or without a warrant? I'd love to know the answer to that. I mean, he wasn't, in Puerto Rico, for example. He wasn't in Guam or anything like that. Territorial possession. Private, purchased island. So one wonders, and what I want them to tell me, and hopefully without me suggesting the answer to them before they do it, is there's only one way I can see. And those of you that don't know about this are going to initially get a jolt here because no one thinks about this, but I got a real good book on territorial stuff, and they had this case in here, and I read it, and I said, damn. So the case is Jones v. United States. I think the case is 202 U.S. 137. Be happy to send you a copy with a request for materials, my modestly priced constitutional defense document packets, unincourt at gmail.com. And I'll send you a copy of this. It's a relatively short case, but the situation was this private American citizen, had done some looking around in that part of the Caribbean Sea, and he found this Guano Islands where all these birds went around and crapped all over the place. And they found out they could make some fertilizer from that and make a business out of it. And they did for a while, for a couple of decades, if not longer than that. And during the course of the time there was a murder committed on the Guano Islands. And the obvious question, with no government presence there whatsoever, what's the jurisdiction and venue? Trial was held in Baltimore, Maryland. This is where the home of the corporate entity that owned this island existed, and you could have made a hell of a defense there on the ground that the corporation wasn't incorporated at all, so therefore no venue. But that didn't come up here because the court ruled and said, yeah, that would be the proper venue here. And the interesting part of the ruling is why they did that, because they said that the Guano Islands, discovered by a private American, and they described this exactly. I'm not kidding. Not a territory. Not even as good as a territory. They were appurtenant to the United States and apparently subject to the complete control of the President acting by executive order as Commander in Chief of the Armed Forces. Now, that's a case that I'm willing to bet anyone high enough in the White House is not only well aware of, but they're telling the Donald, this is the authority you have here, because we're in areas that are pertinent to the United States, not even territories, for Christ's sake. Now, how that could happen, I don't know. But that's the law, and you read that case, that's the only time I think that's ever been to the 904s. But one case, and you look at that and you say, my goodness, how can this possibly happen? So I want the FBI to admit, and hopefully you're not listening there mainly, but if you are, that's the way it is. But to admit without me giving them any clues as to where I'm going that this is the authority they're using, and maybe even mention this Jones case, I'd love to see that. Because I believe that's what they're doing in the 50 states and in all of the, what we think are territories. They're not. They're pertinent to the United States. And that really raises holy hell here because there's no authority to do that. Maybe there was with the Guano Islands. I'm not even sure about that. But how in the world do you reduce a state, to an area pertinent to the United States? And those of you who don't know, by the way, and this is, you read my brief 82 pages on admission of new states, there's a lot of excerpts in that from what I consider the most important issue ever to come before Congress, which was the admission of Maine and Missouri almost 200 years ago. Maine wanted to come in as a free state. Missouri wanted to come in as a slave state, which up until that time, which is what had been happening, because the South needed to maintain, their equal status, at least in the Senate, because they were already outnumbered in the House of Representatives. But if the New Yorkers couldn't get a majority in the Senate, then a lot of the laws that could have been passed that would have negatively affected our rights south of the Mason-Dixon line wouldn't be. And that was one of the big compromises that caused the Constitution to come into effect. It's just that sort of thing, so the South wasn't going to get overrun. And they very carefully set out terms and conditions for the House of Representatives, none of which are being followed today. Racial representation, quorum to do business, and all these representatives have to be, resident in the state they represent. And I've sent letters. In fact, I'll give you a copy of a letter. You can send it to your representatives out there and ask them what state it is that they're a resident of that qualifies them to hold their position in the United States Congress, noting that you can prove that there are no states existing which were admitted into this union. That issue beats them across the board without more. And you probably won't get a reply from your local congressperson, whoever the hell it is, because they won't even understand the issue. But you get in front of a jury of our peers, and they're going to get it because we're going to explain it. And they're going to know they have the power to rule on the facts and the law. That's what we have with trial by jury. We have that safeguard, not subject to control of the State Bar Association. That's why they never want you to know it. So, notwithstanding, however, you might feel about the Epstein situation, I think that search would have been unlawful, and a motion to dismiss that raised these issues would have had to have been granted. And that's initially unfortunate. I get that. Guy was probably guilty of sin, but as I've said in other videos, that's not the issue here. The issue is jurisdiction and venue. And I'm going to say it again. I've got a case telling me United States out of a federal district court. And the case, the judge threw out a federal complaint for murder, knowing that the accused had already been acquitted in the state court and double jeopardy would attach. But the Supreme Court got the decision wrong. But he said, and I quote exactly here, in dismissing the indictment, better that a murder should go unwhipped of justice than that a court without jurisdiction should exercise it. That's the right perspective. Why haven't we seen that in almost 120 years? So as bad as it is on the one hand, once you start letting courts exercise jurisdiction they don't have, and the camel gets his nose in the tent, where the hell do you stop? That's a much bigger issue. So that said, this business with Jeffrey Epstein, and of course it'll be comparatively moot now, and the issue will probably never get before a federal court as to the legality of the search and seizure, unless it does so in an ensuing civil suit. That might be of some interest too. I don't know right now. But I would like to have had Epstein around to have a trial just to see what would have happened there. Unfortunately, we won't. I don't know who got to him or why, and how good his attorneys would have been, and whether they would even have a clue about the issues I'm talking about here. We'll never know. But I just wanted to make you aware there are things worse than federal insular territorial possessions, and we might be in one. Here in California, in Wisconsin, Maryland, wherever it is you are, there are no states. Damn, and we get that issue across, and we get it across to a jury, we will beat them every time. Jurors and composed of fourth graders are going to understand all this, even if law school graduates pretend not to. And they've been there, 4 to 6 years? What the hell did they learn in that amount of time? Geez, what do they have? Co-ed parties 202, 404? I mean, what the hell goes on in these damn law schools? Remind me about that. That's a question I'll send over a written copy to Aaron Chumarinsky over here at UC Berkeley and see if I can get him to answer it. I'd love to hear it. That's it. Like my videos, subscribe, tell your friends. Thank you for listening, and send me an email at youwinnincourt@gmail.com for more information. Thank you.